everyone. I'm Deborah from the Chicago MBDA Export Center. I am the Senior Program Manager. We are one of the programs that are offered under Chicago MSDC. And what our objective is to help you grow your business and scale your business with a focus on you growing your business outside of the US. And our focus is on Africa. So today we have Radiance, and she is a trademark attorney, and this area is her specialty. So Radiance, go ahead and tell them a little bit about yourself, and you can get started with your presentation. Oh, and the other thing, we'll all questions, put them in the chat. That's how we will handle the Q&A. And go ahead, Radiance.
Thank you so much, Deborah. Hello, everyone. I am so excited to be with you here today to talk about trademarks. So today's presentation is Trademarks Made Simple. So my goal is to break down trademarks, the who, what, where, when. What it is, what you need to take note of, and some action considerations. Just want to make sure I can be heard.
Okay, I can hear you now. Yeah, for something happening, it kind of turns
yeah,
off.
something weird. Yeah.
Okay.
Okay, good. Okay, so a little bit about myself. So, there we go. I'm Radiance Harris, and I'm an award-winning trademark attorney, as Deborah mentioned. I'm also the founder and managing attorney of Radiance IP Law. Trademarks are my jam. I've been doing trademarks for well over a decade now. I started my legal career at the world's largest law firm, helping Fortune 200 companies protect their brands. And while there, I was responsible for often sending cease and desist letters and initiating lawsuits. And what I often realized is that I was sending them and filing lawsuits against small business owners. I realized that there was a lack of education about what trademarks are, their importance and value, why you need to protect them, and also why you need to be respectful of other people's trademarks. So I was inspired to leave big law firm life and launch Radiance IP Law 5.5 years ago, where we focus on helping small and emerging businesses protect, monetize, and grow profitable brands with trademarks. So today, that's what we're going to focus on as trademarks. Feel free, throughout the session, if you feel inspired, if there's something that you would like to share or a question you'd like to ask, feel free to drop it in the chat box. I do want this to be interactive. I do want you to get your questions answered and to get a lot out of this presentation. I'm not just going to be a talking head. So I do want to encourage you to drop any questions you have in the chat. Quick disclaimer, go ahead.
Kevin, you can go ahead and turn off your camera. We don't need your camera. Thank you. Okay, you can go ahead, Radiance.
Okay, cool. In true lawyer fashion, disclaimer, this content is resource for educational and informational purposes, does not constitute legal advice, should not replace hiring an attorney, and does not create an attorney-client relationship between you and I. So we're gonna jump into it. I'm going to turn off my camera right now so that we can just focus on the slides here. So just give me one moment to turn off my camera. Okay, so to give you some background about the US Patent and Trademark Office. So the USPTO is the government agency that is responsible for issuing trademark registrations in the United States. In 2020, when we look at the statistics, over 738,000 trademark applications were filed. That was actually a record. Those are record-breaking numbers, the most trademark applications that have ever been filed. Over 400,000 trademark registrations were registered. Again, that's a record-breaking number. This is excellent news. It means that the economic trends are going up. Businesses are starting and growing and scaling, and they're protecting their brands. And this is reflective of both small and large companies. It's not just the large companies that are protecting their trademarks. The small businesses are as well. And so as you see, there's a 10%, roughly 10% increase from 2019 in trademark applications. So this is definitely good news for myself as a trademark attorney, but also for the small business community. So tell me, do you know what intellectual property is? When you hear that term, do you know what it is? If you know what intellectual property is, type a 1 in the chat box for me, just so I have an idea of who I'm talking to. Do you know what intellectual property is? Awesome. We've got some people who do. Great. So intellectual property, all businesses have it. It is your most valuable business asset. It is your competitive marketing edge. What makes you unique. And it is just as valuable as real estate. It can be sold, it can be licensed, it can be transferred. And it can be leveraged in a number of ways, including it can be used as an asset that you can make more money from. It can help you secure funding. If you are interested in government contracts, you're able to get certain government contracts just by having trademarks. You're able to, if you decide that you want to sell your company, it's an asset that you would sell. So it actually increases the overall value of your businesses. And all businesses have intellectual property. So just a quick overview about what intellectual property is for those who might not be familiar with the term. So intellectual property is an umbrella term. It encompasses 4 areas of intellectual property. The first area are trademarks, which we'll focus on today, and that protects words, phrases, symbols, and designs that identify goods and services. So they are able to distinguish your products and services from those of a competitor. The next category we have are copyright. So copyright protects the way ideas are expressed. So original artistic and literary work. So in other words, copyright protects content, your books, your music, artwork, packaging, software, all of that would be protected by copyright. And then patents protect inventions, namely products and processes that you may have invented. And then last category we have are trade secrets, which protects business information. Anything that you want to be kept a secret in your business, whether it's a special recipe, formula, compilation, method, or technique, that would all be considered trade secret. So as I mentioned, a trademark is a way that distinguishes your products and services from those of a competitor. And why is that so important? It's so important because there are hundreds of thousands of other people who are offering the identical or similar product or service as you. And a trademark is a way to make it easy for your prospective clients and customers to find you and give you their money, essentially. So a trademark helps people know the source of your products and services. So when you think of like those big brands, when you see, for example, the Starbucks logo, or you see the Apple icon, you automatically think of Starbucks, you automatically think of Apple. And the same way works for trademarks for you. When people see your business name, you want them to automatically think of you. You want them to think of your products and services. And so with a trademark, you can protect actual words. You can trademark taglines or slogans, such as "just do it." Letters and numbers can also be protected as trademarks. Sounds, symbols. You can also protect scents and other things as well, which we call those non-traditional trademarks. And colors can be protected as well. So that anything that serves as a source identifier for products or services. So there's several types of trademarks. So generally speaking, when you see the term trademark and service mark, those terms are interchangeable. It's just usually a trademark designates something that's being used in connection with products, and a service mark designates something that's being used in connection with services. But really, the terms can be used interchangeably. We have what's also called certification marks. Those are used to certify third parties. So when people have like certification programs, such as like the Energy Star is a certification mark. When you see appliances with that mark, you know that they are certified Energy Star compliant. Collective marks are also an example, such as the realtor mark. It's a symbol of being a collective member of the realtor, the National Association of Realtors. So that's known as a collective mark. And then you have design marks. Design marks are essentially logo marks, anything used as a logo that incorporates some kind of designs. And then you have trade names, which are basically, you know, your business names. And again, if you have any questions, feel free to drop them in the chat. So why are trademarks important? They distinguish you from your competitors. It makes it easy for consumers to find you and make quick and safe purchasing decisions. And to give you an example of this just in real time, so think about like Google, or when people go on social media and when they type in your business name, how many other businesses or competitors come up with the same name? You want to make it easy for them. So like when my prospective clients go in, they type in Radiance IP Law, for example, in Google, I'm the only one that's going to come up. And that's what I want. Like that's what a trademark does. It makes it easy for consumers to find you. It also conveys a message about you and the quality of your products and your services and your values. Again, when your prospective clients and customers see your name, your trademark in the marketplace, what does that say about your particular company? What you offer, what you value? It speaks a lot to that. It's also a very important asset, just like real estate, as I mentioned. Intellectual property is your business asset. Like that is the thing, the tangible thing that you can leverage and pass on to make more money in the marketplace. And then most importantly, it never expires. As long as you're using the trademark and then filing the necessary paperwork with the US Patent and Trademark Office, you will continue to have those trademark rights. So there's two primary goals of trademarks. And so I mentioned this a little bit earlier, but I wanted to kind of break it down to you. A trademark safeguards the public from confusion. So I mentioned earlier that when your prospective clients and customers see your products and services, you want them to not be confused and think that you're related to or affiliated or endorsed by another company in your industry. You want it to be clear and easy for them that you are the only company in that industry with that name, and that when they're coming to you, your products and services, there's a certain guarantee of quality. But a trademark also protects the business's investment of energy, time, and money in promoting their brand, establishing goodwill, and preventing misappropriation. So the two primary goals with the trademarks are not only to protect the consumers, but protect you as the business owner. Like think about all of the energy, the time, and the money that you've invested in building this business, only to find out that, oh man, I'm infringing on someone else's trademark and now I have to rebrand. That would be very unfortunate and very annoying. So that is why you need a trademark, because it's going to protect all of the blood, sweat, and tears that you've put into your business thus far. So there are essentially two ways to establish trademark rights. The first way, so right now you don't have a trademark. Let's say you've been in business for 5 years and you're located in Maryland. I'm located in Maryland, so we'll just use that as an example. You offer a service or a product that you sell that's accessible online, and you've been using a name for 5 years, but you haven't secured a US federal trademark registration yet. You would have what's called common law trademark rights. These are very limited rights, limited to you where you are located geographically. So I'm in Maryland, so I'd be in Maryland. I'd only have common law rights in Maryland. So I could prevent a competitor from opening the same or similar business to mine in Maryland. However, what if a competitor steals my name in Virginia and then they open a business, or in DC, or in New York, or in California? I would have no protection or recourse. I could not prevent them from doing that because I only have common law trademark rights. But that is one way of establishing very limited trademark rights, which we call common law trademark rights. However, with the federal trademark registration, when you secure that, you now have nationwide exclusive right to use your name in the United States. So even though I'm based in Maryland, but my products and services are accessible online, I now have nationwide protection against anyone in the United States. So if anyone in the United States decided to steal my name or my logo or what have you, I would have legal recourse to prevent them from doing that. I have a question that comes in, does federal registration cover our territories? I'm not sure what you're asking, but a US federal trademark registration covers all 50 United States. It covers all 50 United States. It does not cover international. We'll talk a little bit about that later because trademark rights are jurisdictional, but it does cover the United States. So I think that's answered your question. So the first thing you need to know or should know about trademarks is the importance of having a distinctive name. Not all names are created equal, and not all names are what we call trademarkable. So do me a favor, type your business name in the chat. If you have a business or a product or service name that you like, drop it in the chat, just so I can see what we're working with. Awesome. We've got JGMA, Scene Chic, Fellowship Fleet, Insight Financial Group, Mega Graphics Design, Sidereal Global, 713 Enterprises. Awesome. Thank you for sharing. So I always say that the more your name describes about your business, the less eligible for trademark protection it is. And so the best inherently distinctive, as we call it, or the most unique names have the highest trademark protection. So when we look at this continuum of like distinctiveness, at the very, very top, these are the names we deem like the most distinctive or the most unique that are subject to the highest trademark protection. And that's Google and Kleenex. So these are basically names that are invented or consist of made up words. Those are the best types of trademarks because you know without a doubt, if you see it in the marketplace, who it is. Then the second level would be what we call names that consist of words applied to unrelated products or services. We call arbitrary. So like, for example, Apple for computers, Camel for cigarettes. Those are also the best types of names, business names, because again, the word is not as unrelated to the actual product or service. Then the next level, we have our word suggesting a characteristic or feature of the product or service. So these are what we call suggestive marks. And these are such things as like copper tone, which is suggestive of like the copper tone of your skin when you use their suntan lotion, or snuggle, which is suggestive of the soft and cuddly feel of the material once you use their soft, their softener. So those are also protectable names. But as we go a little bit lower, the more descriptive you become, the more difficult it becomes to trademark. And so, for example, anytime you have a word that describes, anytime that your business name consists of wording that describes a characteristic or feature of the products or services that you are offering, then that is deemed descriptive. And it's very challenging to trademark descriptive names unless they meet certain requirements. And that requirement, basically the requirement for descriptive names is that you have to prove acquired distinctiveness. And what that means is that we have to basically show that this person has been using this otherwise descriptive name for at least 5 years or more, so much so that the name has become distinctive to that business. And so only after 5 years of exclusive use, continuous use of a descriptive name, can you get a trademark. And examples of those are Saturday Night Live and Capital Area Food Bank, all of which at one point were deemed descriptive, but then were able to get trademarked after showing acquired distinctiveness. And then at the very bottom are generic names. So generic names, there's no protection for those whatsoever. You can't protect a name that describes a class or categories or products or services. So those are not even in consideration. But the higher you are on the chart in terms of the nature of your name, you are good to go in terms of being eligible for securing trademark protection. So why is it so important to have a distinctive name? So for starters, it distinguishes you from the competition. It's memorable, it's different, allows you to stand out. Again, it makes it easy for consumers to find you. And then it conveys a message about your products and services, that you're unique, you're different, you stand out, and here's why. Someone asked a question in the chat, what about when people coin a catchphrase? So you can only secure trademark protection for a catchphrase if you're using it in connection with a product or service. So that's what determines a trademark from just saying, someone might be known for saying something. Like at one point, what was that? What was her name? I'm growing the rapper who said occur. She tried to trademark that, but because it was such a widely used term, she wasn't able to get trademark protections for it because it was a widely used term. But there are other times where you can, if it's a catchphrase and it's unique to you and it's being used in connection with products and services, then you can absolutely get a trademark for that. So it kind of just depends on the facts. So distinctive ultimately is what will make you stand out and make more money. So 72% of the best brands are made up of words or acronyms. So as you see, the more the names that we are starting to know and love in the marketplace, again, the big brands that we know and love right now used to be small businesses. And so they later became big brands because of that brand recognition, because they protected their trademarks early. But those also are the ones that became the most profitable because they came up with distinctive names. And so here are a few examples of distinctive names, that you probably know and familiar with: Google, CBS, Adidas, Nissan, Toyota, Lexus, ESPN, NBC, Puma, Xerox. These are all examples of names that, don't exist in the English dictionary and are distinctive and are registered trademarks. Also, 77% of consumers make purchases based on a brand name. So your brand name does matter in the marketplace. So the second thing you need to be mindful of, it's part of the trademark process, is the importance of doing a trademark search before adopting your business name. Drop a 3 in the chat if you actually did a trademark search before adopting your business name. Or did you just come up with it and then, run to file an LLC and then get the domain names? Drop a 3 if you actually did a trademark search. Okay, great. There are a couple of people who did. Okay, well, a search is the most important first step before adopting a name. And so it allows you to find out valuable information about the proposed name you're using. Is it available for your use? Does somebody already have trademark rights in it that you could be infringing? It allows you to determine the strength and scope of your protection. For example, you might have come up with a name. For example, oftentimes in, for example, the clothing and apparel space, there are certain terms or names or words that are heavily diluted. So for one of them, it's melanin. Like everyone, for whatever reason, in 2020 and beyond, wanted to come up with a clothing line with the term melanin in it. And so when you do trademark searches, you can see, oh, maybe I want to stay away from using melanin because there's so many other people out here using it, and how am I going to stand out? So that's what a search does. It not only gives you information about whether or not it's available for use and registration in the United States, it actually will give you insight as to how strong is that name. That's something that, I should consider protecting. It also allows you to understand any risks out there, plan for any strategies or contingencies. So like you do see that there's a potential obstacle, like how might you be able to get around it or mitigate those certain risks. You can also avoid potential negative connotations. So a lot of times there's people who go what we call trademark diving, and they go on the register and they look up and see, you know, what marks have recently been abandoned that are no longer in use. So they'll go and look at all the dead marks on the register. But sometimes, you know, a name that you might have or planning to use could have a negative connotation associated with. So maybe the former company went out of business because they were known to poison their poison their customers or something. And then here you come and you want to use the same name doing a similar product or service. So it's important to do a trademark search for all of those reasons. It's a very valuable first step before adopting any name or logo for your business. So what I mean by a trademark search is looking at the USPTO records, business records, internet search, social media search, Amazon search if you're doing products, domain name searches. You're looking at all of these places and you're not only searching the identical name, but you're looking at variations of the name. So a lot of times, you know, people go to the USPTO site and they say, oh, no one's using my name because the identical name, you know, didn't pop up. But in trademark law, the standard for trademark infringement is likelihood of confusion. So even if two names, so let's say two competitors in the same field are using similar names, the names don't even have to be identical. They can be similar. There could be trademark infringement. But a lot of times you're not going to catch that when you do your own search, but at least it's still important to search variations to be able to account for different variations in spelling, phonetic sounds, things of that nature when doing your searches to confirm that the proposed name that you want to actually use is available. And another misconception I want to add, a lot of people, when they go to file for a business entity with their Secretary of State, they might see that, oh, my name's available as LLC. That means I'm available. The name's available. When you go file with the state and do those business entity searches, that is not clearance that the name's available and you're not committing trademark infringement. Because the Secretary of State does not do trademark searches. They are not letting you know if there's someone out there whose rights you could be legally violating. A business search just lets you know that someone with the identical name is not in your state, or it could be as simple as your name, your company, my name of the company is Radiance IP Law, and someone goes and files for Radiance IP Law firm in the same state. The LLC Secretary of State business records is not going to flag that, but a trademark search would flag that as trademark infringement. So that's just something to keep in mind. So there are a lot of risks to not searching. One is, you're spending a lot of money building your business, building your brand, you've invested in your website, you've invested in your marketing, you're getting a lot of publicity and traction, and then bam, you receive a cease and desist letter, or as we like to call, a nasty gram. And so those nasty grams can stop you in your tracks. So everything that you've worked hard to build and your name out there, the business name that you've been promoting, now you're stopped in your tracks and you have to switch gears and completely rebrand everything. So that's your website, that is your storefront if you have one. It's now you have to change your social media, you have to get new domain names, you have to change all of your business infrastructure. Everything has to be changed. And then, God forbid, you get sued in court for damages and attorney's fees too. So not only have to rebrand, but now you have to defend yourself in court. So that is a loss of your investment, a loss of your profits, stress, just time-consuming, major headache that can all be avoided by conducting the initial trademark search and then filing a trademark shortly thereafter. It's no good to you to do the trademark search 3 years ago, not file for it then, and then file for it years later because okay. So it's best to, do that now rather than wait to do it later, or do it prior to adoption rather. So as I mentioned, trademark infringement is the key issue a lot of times. And when adopting a name, you want to make sure that any name that you adopt is not identical or similar to a competitor, which could potentially lead to potential or actual consumer confusion. Because for trademark infringement, actual consumer confusion does not have to occur. We look at what is the likelihood of it. So like, for example, if you think of like Gillette company, they use, they sell a right guard for deodorant, but then a competitor comes out and spells right differently for a similar product. Just because right is spelled differently and they combine the words together, that does not mean that the marks are different or that there's not going to be any confusion. So it's important to be mindful and respectful of others' prior trademark rights when you're adopting new names, and being mindful that you're not, unreasonably misusing their trademarks, because a trademark infringement case is very expensive. Not considering legal fees and all of that, but if they do prevail, you're looking at damages of at least 1 million or more. That's the average award in a trademark infringement case. So it can be quite costly. So as I mentioned before, once you do the trademark search, you want to promptly file for the US federal trademark. And so the US federal trademark registration is a very important step. And so here are just a few examples of things that you can trademark. So you can trademark business name, you can trademark your logo, your tagline, product or service names, if you have an event name, a course name, a podcast or blog name. If you're selling a mobile app and you're using icon, that can also be trademarked. You can actually even trademark hashtags that are used in connection with products or services. And on this slide are just a few clients that I've helped with getting trademarked, just so you can see the types of things that can be trademarked. You can trademark word marks, so where you just trademark the actual words. You can trademark stylized marks. So there are a number of things that you can trademark and should trademark. So there are a lot of benefits to securing a trademark. One is nationwide priority as the application filing date. So one thing you might not realize is that you can file a trademark application based on an intent to use, and you can file a trademark application based on current use. So if you are currently using a trademark, you can file based on current use. But if you're thinking of launching a product soon or launching a new business soon, anything in the near future, let's say within the next year or two, we can file based on an intent to use. And when you file based on the intent to use, you're able to stake your claim to that name while you're getting your business affairs in order. And so when you file based on the intent to use, you have nationwide priority as of the application filing date in those cases when you file based on the intent to use. And then when you're filing based on current use, you have nationwide priority as of your date of first use. That's when your priority date. So let's say your date of first use was November 30th, 2015, but you just filed the application this year. Your priority from an enforcement standpoint would be basically when the application was filed, but you have priority as of the first date of first use, which would be November 30th, 2015. I hope that makes sense. I'm not confusing you. There's also the presumption of validity, ownership, and exclusive rights to use the mark. So I always say that a US federal trademark registration functions as a birth certificate for your business. It's automatically presumed as valid. No one's going to dispute that, oh, you don't own that. You have a trademark registration, so it's undisputed. And so that's the beauty of it, is that when you have it, it's undisputed. So if you do have it and you find out that someone is infringing on your trademark, you send them a nasty gram, a cease and desist letter, and you reference the registration number, no questions asked, automatically presumption of ownership. If you don't have a trademark and you find out someone infringes on your rights, you don't have that same presumption. You also get enhanced remedies for infringement. So you would be entitled to 3 times the damages and attorney's fees if you did have to sue someone for infringement. If you're selling products, you have protection against importation of counterfeit goods registered with the US Customs. You have the right to use the registration symbol. So the ability and right to use the registration symbol is only allowed once you have a US federal trademark registration. That's the only time. Not when you start the trademark application process, only once you've actually secured a registration. And then lastly, the ability to license, assign, or sell trademark rights. So it is an asset, as I mentioned, that can be leveraged to make money. And it's a way to make passive income for your business. So something to think about. So a lot of us, we're on social media, we're on our business, we're promoting our business on social media. We might be selling products on Amazon. Amazon does require a US federal trademark registration to sell in their marketplace. Same with the social media platforms. If you ever found out that someone was infringing on your trademark rights on the social media platforms, or they started a handle or they're selling similar products or services, the only way to get that stuff taken down is with a US federal trademark registration. The social media platforms will not entertain any intellectual property claims without evidence. And what they say is evidence is a registration. They will not entertain anything else because they don't want to get in the middle of any intellectual property disputes. So that's another benefit, is that because it is an automatic presumption of ownership, it's a lot easier to get what you need in terms of being able to nip any enforcement or infringement issues in the bud before they can get out of hand. So these are some designations that you probably see often in the marketplace. So the TM or the SN designation is what you see a lot of people use. Essentially, it puts others on notice of your intentions to trademark, but anyone can use it. It really doesn't hold any legal weight because anyone can use it. Like a lot of times people just start using a name and they slap the TM designation on and they think that they're protected based off of that. But as I mentioned before, at a minimum, you'll have what's called limited common law trademark or service mark rights in the state based on your use. Even if you are shipping and serving clients nationwide, or in some cases internationally, that doesn't matter because it's all about where you're based. And so right now, if you are using a product name or business name without a US federal trademark registration, you can use the TM designation. It may dissuade some people from using it, but it doesn't really hold any legal teeth when it comes to protecting your trademark. And so that's something to keep in mind. The registration symbol, however, it puts others on notice of your US federally registered trademark rights. You can claim nationwide trademark or service. It shows that you have nationwide rights. Only trademark owners can use it, and you can only use it after you receive your US federal trademark registration certificate. That's the only way. But that designation, the registration symbol, holds teeth, holds legal weight, and can take you a long way. So it's important to note that trademarks are jurisdictional. There is no such thing as an international trademark. So you will have to secure trademark protection in the countries that you have a commercial presence. And so once you secure the US trademark in the United States, there are options where you can actually secure protection internationally as well. through a process called the Madrid Protocol. And that's a process that I work with my clients on. The Madrid Protocol is a system where you can file in up to 129 member countries. Of your, you'd have to designate which countries are of interest, but it's one application that you complete, and then the US Patent and Trademark Office shoots that application out to those countries of interest for their individual assessments and determinations. However, if there are countries that are not a part of the Madrid Protocol, then you would have to obtain counsel in countries of interest to secure protection. And this is particularly important. International protection is particularly important for those, let's say if you have products and your manufacturer is in another country, let's say India or Africa. If you're looking to do business in Africa, as I understand that is the main focus of the center here, then that is a consideration where you would want to consider pursuing and getting trademark protection in certain African countries of interest, and also any manufacturers, or if you tend to travel internationally to provide certain products or services, any of those countries would be considerations for trademark protection. But it's important to note that each country has its own set of trademark laws. Some countries may be covered in the Madrid Protocol, in which we can do a more centralized trademarking process, or you'd have to secure actual assistance from a local trademark counsel in the country of interest. So I often get the question, when you need to trademark. Someone asked, what about Africa Free Trade Agreement, Zimbabwe under Madrid Protocol? What are you asking particularly about that? I'll continue until you respond. I want to know, what are you asking specifically about? Are you asking if Zimbabwe is in the Madrid Protocol, or we can come back? Okay, so when you need to trademark. So I don't have the 129 countries memorized. I believe Zimbabwe may be a part of the Madrid Protocol, but I don't know off the top of my head, but assuming that they are a part of the Madrid Protocol, then we'd be able to file based off of a US trademark application and or registration in Zimbabwe through the Madrid Protocol. So it's a way to streamline it. And the beauty of the Madrid Protocol, that I forgot to mention, is that if you file within 6 months, if you file through the Madrid Protocol within 6 months of filing your US trademark application, the priority filing would be the same date as your US application. So let's say you filed it April 25th, 2021 in the US, and then if you filed your Zimbabwe application, let's say August 2021, your filing date would be the April 25th date. So that's just something cool to realize if you file it within 6 months. If you don't file it within 6 months, then you don't get the benefit of the earlier priority date. Okay, so when do you need a trademark? I often get this question about when is it a good time? So a good time to trademark is before adopting the name, tagline, or logo. So that is ideal. Before you adopt a name or tagline or logo, like that is the ideal. Before licensing is also a good idea. So if you have any intentions on licensing, and that's like, maybe you've created a signature program that you want to license, or you're selling a course, that's a form of licensing. Anytime you're looking to license anything, sell products and license the name of the use of your name on other products, anything licensing related, you need a trademark for, because you can't license something that you don't own. Also before any brand extension. So if you're looking, let's say you have a trademark, and when you got the trademark, you were offering a certain amount, you were offering specific products and services at that time. But now 4 years later, you've pivoted a little bit because of the pandemic. So now you're offering some other things. Those are other times where you'd want to trademark for those additional items and services before any brand extensions, because you want to see, are you able to actually use that name in connection with these new products or services? Because sometimes you can and sometimes you can't. Sometimes your proposed name might be available for some products and services, but not all of them. So you want to be able to get it trademarked and start the process before any brand extensions. Certainly before expanding geographically, you want to get a trademark, and then definitely before hiring any staff. And that includes independent contractors or anybody, because when you don't have your intellectual property protected, particularly your trademarks, that means now your staff, anyone who works in your business, can have a claim to the trademark, to the name. They can say, oh, I helped come up with it, or a disgruntled former partner might branch off, and now you've got two identical companies with the same trademark because it was never protected. So it's just important to think about these times where it's, you should really think about trademarking. We have another question. So does the trademark and or patent issuance, including domestic and foreign countries where the company will have products or do business, deter the possibility of knocking off the product or service? So if you're definitely if you're in the United States and you've got a trademark for something, someone can't then file a trademark for that name, doing like for a competing product or service. So a competitor cannot go and file a trademark for your name. So just to give you an example, so the name of my law firm is Radiance IP Law. When I launched my firm, I filed for the trademark, process. I now have a registration for it. Last year, another law firm tried to file for Radiant for legal services. I have protection for Radiance IP Law. Of course, they tried to file for it, but the USPTO blocked them. The USPTO cited my prior trademark registration as a barrier to them getting a registration. So they were blocked, couldn't obtain a registration. On top of that, they received a nice nastygram from my firm demanding that they stop use. So not only can it potentially, a trademark registration deter others from doing it, but you can physically prevent people from knocking off your name, your brand name, your logo because of that trademark. And so if I have a protection in the United States, though, that doesn't prevent someone in the UK from starting Radiance IP Law, unfortunately. So if I were to expand it, internationally, I would have to get protection for Radiance IP Law in the UK. So I would say that is a consideration. That's why if you are doing business internationally and from a cost benefit standpoint, it makes sense, then you might consider pursuing trademarks in those countries of interest, because otherwise there is nothing that would stop someone from just knocking off your product and then launching it in another country, because it happens. So I hope that answered your question. So it's something I want you to really remember, is that the big names were once small. So the Apples, the Googles, the Amazons, Disneys, Mattels were small. They started in their 2-bedroom apartments. They started in their garage. They started their businesses in their basements. But what is the common denominator of all these small companies is that they filed their trademarks before launching their business or shortly thereafter. When you pull up the trademark records for each of these companies, their applications are either filed based on an intent to use, which means they filed the application before they even launched their business, or they did it shortly after launching their business. And so that is an important thing, that it really distinguishes what you call the successful businesses from those that don't end up becoming as successful because they didn't think about protecting their brand early. Because what brand protection does, particularly trademark protection does, it gives you options as you grow. So right now you might be, small, but you might not always be small. And so if you get the trademark now, as you're growing, you will then have options to do more, to make more money, to go on to other areas. If you wait until you wait to become the business that you envision, once that happens, you might not have the options, or you may have to end up rebranding at that time, which would be incredibly expensive and disheartening to have spent all that time and years to grow that business, to then not be able to use and carry on that name that you've worked so hard to build. So this is just something I wanted to make it known to you, that the giants were once small, and the steps that you take now as a small business is what will set you up for the success and the vision that you see for yourself in the future. So what is the risk of running your business without trademark protection? And this is just a quick summary. I've already hit on a lot of these things already, but it'll make you indistinguishable from your competitors. You're just going to fall into the pot with everybody else who's doing what you're doing. You wouldn't have any protection from legal disputes or lawsuits. There's no protection from someone stealing your name. There's none whatsoever. No legal foundation to grow and scale your business. There's always going to be the risk of having to potentially rebrand later. And then most importantly, you will lose a lot of time and money that you've built in the brand if you continue to run your business without establishing trademark protection. So invest, the moral of the story is invest early to avoid major loss later. So a lot of people ask, is it best to DIY or hire a trademark attorney like myself? So just to give you a quick summary of like what to expect. So with a DIY, if you tried to DIY this process, for fees you'd be looking at, you'd have to pay the USPTO filing fees. The current fees right now are $250 per application per class. So DIY would be you spending the time trying to learn the process. So as you know, time is money, paying the filing fees, and then just using like the free Trademark Search tool on the USPTO website. Then you've got what we call online document filing services. So you've got like the legal doom, as I call them, not LegalZoom, but legal doom. And then you've got the like Trademarkias and places like that. So they just file a bunch of documents for you. So with those, you might spend $500 or upwards plus the filing fees. They do a very basic trademark search. They'll prepare and file your application. But it's important to note, you're neither working with an attorney or a law firm, and especially not a trademark attorney or a law firm. And in fact, these document filing services clearly state on their website, we are not a law firm, we are not attorneys. So they do not provide legal advice or recommendations. They do not provide responses to any complications or refusals that you receive from the USPTO. So in fact, a lot of people go to LegalZoom and thinking that they're, getting a great deal, and realize that they've wasted their money, because LegalZoom did exactly what you told them to do, even though it was wrong. Like LegalZoom is not going to tell you, oh, nope, that's wrong. You should do this. I would recommend this because this is better for you based on your vision. They're not going to give you any legal advice. They're going to do exactly what you tell them to do. And so that's something to be mindful of when looking at online document filing services. The next example is hiring an attorney. So hiring a trademark attorney. You could expect to rate, depending on who you're working with, anywhere between $1,500 to $300 plus any USPTO filing fees. With an attorney, you're going to get a comprehensive trademark search, or you're going to get a thorough search and a formal opinion on your chances of securing a US federal trademark registration. You're going to get expert legal advice and recommendations and the strategies that are customized based on what your business goals are. You're also going to get help with application preparation and filing, and then they'll handle any complications and refusals from the USPTO on your behalf. And it's important to note that the trademark process is on average about a year long. So it's not a quick process that you may think, like when you went to go file like for an LLC or a corporation, and then like 5 days later you're established. The trademark process isn't like that at all. The trademark process is lengthy, and it can take quite a bit of time. Let's see, I'm looking at other questions. Can you use a trademark attorney in other states? Yes. So trademark law is a federal practice. So we work with clients nationwide, so across all 50 states, as well as internationally, if they want to secure protection in the United States. So you do not have to work with a trademark attorney in your state. Trademark law is federal. Another question, when a company filed for a trademark is completely out of business, can a new company adopt the trademark? Yes, if there's a company that filed that is completely out of business, but their registration has been abandoned. So it doesn't matter that if, let's say someone has a company has a trademark registration and that registration's like 4 years old and they went out of business last year, but they still have their trademark registration. That's going to be difficult to do because you're not going to be able to trademark it because you still have an active registration despite going out of business. But if they're out of business and their trademark registration has lapsed, and assuming there are no other issues or conflicts, you could possibly trademark that name. But as I mentioned in an earlier slide, you should kind of investigate and research that prior company, make sure there's no negative associations or anything like that that could potentially fall onto you. Another question, should you be discouraged if you see companies with the same name already registered? Yes, if they're doing what you're doing, if they're offering similar products and services to you, so let's say identical, similar, or related, doesn't have to be products or services to you, and they already have a trademark for it, then that's a pretty good sign that that's not a good name to trademark. What if a company has one name as a business but goes by a nickname or a DBA, but like a combination of the real name has been coined? I don't know what you're asking there, but the main thing is if there's somebody who's already in the marketplace offering a product or service for a name that's identical or similar to yours, and they have prior trademark rights to you, and they have a US federal trademark registration, that's a good indication that the name is off limits. Like if your business name is Radiance IP Law, but you coined Ray Law, it kind of depends. Like I coined it or the other business coined it. I guess that's what I'm confused about what you're asking, but it kind of, then I would, if I have a business name but then I have an abbreviation for it, then I would get trademark protection for both of those. If I'm gonna use if I'm using my full name and that's the name I'm using in the marketplace, and I have a coined abbreviation for the name, I would secure trademark rights for both of those. So hopefully that answered your question. So yeah, so that's the difference between a DIY online document filing service and hiring a trademark attorney. As you see, all the options are not created equal. You essentially will get what you pay for, and you kind of will know what to expect with any of these options. So here are a few statistics you should know. Hiring a trademark attorney will increase your chances of securing a trademark registration by more than 60%. Also, 70% of trademark applications receive an initial refusal. So I will say in the past couple of years, the USPTO has become increasingly aggressive with refusing applications. And I think it's because in the last few years, there's been a lot of fraudulent trademark applications coming out of China. And so in order to, I guess, prevent those from going to registration, the USPTO has become increasingly aggressive with initially, issuing initial refusals. So only 30% of the applications now get through without an initial refusal. And so if you do get a refusal, it's going to be difficult to handle those as a DIY. LegalZoom does not handle those. You would need to hire a trademark attorney to then get around that issue. So that's something to keep in mind. So then let's do a quick trademark checkup for you. Ask yourself, am I using a distinctive, unique name? Like, is my name distinctive and unique enough where I should consider trademarking it right now if I haven't done so already? Did I conduct a trademark availability search prior to adoption of this name? If not, do a search, see what's out there. Did I pursue any US federal trademark registrations? So if you did do a search, let's say a couple years ago, but you haven't pursued a US federal trademark registration, well, now's the time to do a new search and then pursue a US federal trademark registration. Am I using the proper designation? So right now, if you don't have any registered trademarks, the TM designation is, you can certainly use that, but as I said, it doesn't hold any legal weight, but it's at least a way to notify people of your intention to trademark. The other thing that we didn't go too much into, but am I monitoring and policing for trademark infringement? So once you do get trademark protection, are you making sure that you're enforcing it? Are you making sure that there are people that are not popping up in the marketplace or on the Federal Register with the same or with the identical or similar trademark to yours? Another question is, if you do have any current trademark registrations, did you renew them? So a lot of people are like, oh, I filed a trademark, 7 years ago, but they didn't realize that you have to actually renew the trademark with the trademark registration with the US Patent and Trademark Office between year 5 and 6, between year 9 and 10, and then every 10 years after that. So basically, once you secure trademark rights or trademark protection through the USPTO, so long as you continue to use that trademark, your rights are indefinite, so long as you file the necessary paperwork proving that you're still in business and still using the name between year 5 and 6 of the registration, and then to year 10, and then year 20, year 30, and so on and so forth. You have no idea how many people are like, oh, I didn't know I had to renew, and then their trademark registration lapse, and then they have to start the process all over again. And then the last question, did I pursue trademark registrations in the countries outside of the United States if appropriate? So these are all good questions to ask yourself. So if you are ready to take action, here are 2 ways. If you want more detailed information about the trademark process and what it entails and how to do the search and things of that nature, you can certainly look into my best-selling trademark book, Trademark Like a Boss, which is available for purchase on my website with free shipping. If you want more customized strategy, if you're looking for a customized trademark strategy for your business, you can certainly schedule a trademark strategy call with me through my website as well, radianceiplawcom/book online. And I just realized that my slides are missing the IP. Okay, so I'm going to put that in the chat box, the correct URL if you're interested. And you can also feel free to send me your questions. Now I'm happy to answer any questions before we wrap up.
And Radiance, can you tell them a little bit about what you'll talk about on Thursday? Because it is not the same content.
Correct. Thursday is not the same content. Actually, Thursday will be my signature Trademark Like a Boss training, where I'll literally walk you step by step through the process. Here's how we do identifier trademarks. Here's how we determine which trademark classes. Here's how you'll determine what trademarks you should protect. Here's what the process. So basically Thursday will be all about the how. Today was about what, who, when, why. Thursday will be all about the how. So it's going to be a totally different presentation. Any other questions? And the special promo code is available through Friday. $50 off trademark strategy call. If anyone's interested in scheduling a strategy call, just use the promo code MBDA for $50 off through Friday. Are the laws governing trademark or trademark registration standardized across the world? No. Each country has its own individual set of trademark laws. So each country has their own laws. So I can only speak to US trademark law. Okay, well, if we don't have any more questions, we can certainly wrap up. Thank you all so much for joining me today. I hope that you found a lot of value from today's session.
All right. Thank you, everyone. Good night, and we will see you on Thursday. Bye.